Thank you. We're hearing our case 1 CACB 150786. I'm Amberwood versus Swanns. Each side will have 20 minutes for argument. Appellant, you may reserve any amount of that time for rebuttal, but you'll have to keep track of that time on your own. Each counsel can look at the clock at the podium. We are recording this argument both in audio and video. As you come forward, please identify yourself and your client so that we can keep track of who's who for the recording. The video will be up on YouTube in a few days, so if you want to view the argument again and be YouTube stars, you can see it there. We've read the briefs and examined the record, and we're familiar with the arguments of counsel, so when you step up to the podium to begin, just launch right ahead into the argument. Counsel, you may begin.
Good morning. May it please the court, my name is Lynn Allen. I represent the appellant Swanns Grading in this case. I'd like to reserve about 5 minutes for rebuttal argument. This case involves an issue of first impression, which is the interpretation and application of an indemnity agreement where multiple subcontractors were a cause of the same construction defects and damages. In this case, we believe that the trial court erred in interpreting the indemnity agreement to require the only non-settling subcontractor, my client Swanns Grading, the last man standing, to pay the full amount of the damages without allocating damages among all of the responsible subcontractors. So this case requires the court to interpret and apply the indemnity agreement in the contract between Amberwood and Swanns Grading. We've set forth in our briefs the standards for interpreting an indemnity agreement, but what's most important here is where the agreement is ambiguous, it must be construed against the indemnity, the drafter of the indemnity agreement, and that would be Amberwood. So I want to talk first about why the indemnity provision is ambiguous.
Can I make sure I'm clear about your premise? Did you say that the upshot of the judgment here is that your client is being required to pay for everybody else's fault?
Yes.
Is that true?
Absolutely. It was actually in the trial court's order. The trial court recognized that it was holding Swanns liable for all of the damages. There were a number of defects, and then for each defect there were a number of subcontractors. The trial court expressly held it was holding Swanns liable for the full amount of those damages, even though other subcontractors' work contributed to those defects.
My understanding that what the judge was saying was that the allocation would not be based on allocations of proof of negligence, but there still was an allocation by percentage, and there was an offset. Did not those things mitigate your premise somewhat?
Well, no, because we believe, and I believe it's expressed in the minute entry, that what the trial court did was took the full amount. There were two judgments per se. There was the judgment on the arbitration plus the settlement. So that full amount, what the judge did was break down from the full amount what was attributable to the defects that Swanns' work was implicated in. But the court acknowledged that there were other subcontractors responsible for those defects and held that the Swanns would be liable for the full amount of damages, even though
that Swanns was held responsible for all of the damages that Amberwood was said to have caused.
That is true.
but rather that Swanns was required to pay for all the damages that was attributable to the work that Swanns was involved with.
Right, even though there were other subcontractors involved in that work, and the court acknowledged that it was holding Swanns responsible even though other subcontractors were involved in that work. And then what the trial court did was deduct or reduce that amount by what was paid in settlement by those other subcontractors, which worked out to be about $13,000 per subcontractor.
So Swan, in the instance, Swanns we're going to be able to seek contribution from the other subcontractors because that's already work. Their payment to Amberwood is already in the mix, correct?
Right. Their payment to Amberwood was deducted from what the trial court found the full damages to be. Now, whether or not Swanns can seek contribution is really an open issue. Swanns has filed suit, but that suit's been stayed pending the outcome of this appeal, from my understanding. That's not in the record. I just learned that.
So Swanns, in the end, may not have to pay for the negligence of the other subcontractors.
It's all going to depend on whether or not it can state a claim for equitable contribution against the subcontractors. We don't know that it can. And it's also going to depend on things like the statute of limitations. It's going to depend on whether or not the releases that were given to the other subcontractors bars Swanns from seeking contribution. So it's really very much up in the air and in doubt whether Swanns would be able to recover any amounts from the other subcontractors, which is why it's imperative that this indemnity provision be construed in a reasonable manner according to the words of the indemnity agreement to require Swanns to only indemnify Amberwood for those damages that are related to its acts or omissions. There's nothing in the indemnity agreement that requires Swanns to indemnify Amberwood for the acts or omissions of other subcontractors. And the effect of the court's ruling is really almost a strict liability. If Swanns had a hand or a rake in a lot where there are 5 or 6 other subcontractors whose work also caused the defects, Swanns, because it didn't settle, gets stuck with $1 million plus judgment.
Or should probably be, would you be taking the same position if Swanns was one of those subcontractors that settled with the contractor and left another subcontractor hanging in the wind?
Well, I believe that the other subcontractors were making the same arguments on summary judgment that they should only be responsible for what damage was attributable to their work. So yes, this is how this indemnity agreement should be interpreted. They fortunately were able to settle out for cheap, so they don't have to worry about it. But it means what it means, whether I'm subcontractor A or subcontractor B who settled out or the general contractor.
Were the defense costs here absorbed entirely by Swanns and its liability carrier? The defense costs for the trial?
The defense costs for the trial on the indemnity claim, are you asking whether Swanns has insurance or? Well,
I assume the agreement said it pays the cost of defense.
Right. So there are 2 separate attorney's fees awards in this case. The first had to do with the attorney's fees incurred by Amberwood in the defense against the plaintiff homeowners, and then the second was the indemnity costs or the attorney's fees incurred in pursuing indemnity against Swanns. So the court ordered Swanns to pay both of those.
Right, 100% of it?
Yes. Well, as to the first, now remember, Swanns had provided a defense to Amberwood up to and through the settlement with the plaintiffs, and so we argue Swanns shouldn't have paid any additional defense costs. But whatever defense costs were unpaid, the trial court ordered Swanns to pay 100%. And then as for the indemnity, the third-party complaint against the subcontractors, the trial court ordered Swanns to pay 100%, even though Swanns had presented evidence that about $44,000 of that was incurred chasing the other subcontractors.
But presumably each of these other subcontractors had the same indemnity provision in their subcontract agreement with the contractor, right?
They did.
So, and why is it you're concerned about the likelihood of an equitable subrogation or equitable contribution action?
Because Amberwood released those subcontractors, so they do have an argument that they owe no more.
Counsel, if your client would enter into an agreement where it would be responsible without regard to negligence, could they so contract? The argument is that Swanns is responsible simply for being there, correct?
Right, that's the effect of the holding.
Could they readily contract that way if they so chose?
Well, the problem, and I think this is illustrated by the California case of Hepler that we discussed in our brief, the problem is the inequity between, the strength of the general contractor and subcontractors in the context of a multi-home residential development.
Are you saying that provision is unconscionable?
No, I'm not saying it's unconscionable. I'm saying that the surrounding circumstances of the project and the agreement needs to be taken into consideration when construing the provision. And so the courts have held, even Arizona courts have held, that it's not a mechanistic approach. The word negligence does not have to be used for a court to find that a showing of negligence is required. And so we have an indemnity provision with two paragraphs that conflict with one another. We have one that says that the obligation to hold harmless it has to arise out of the acts or omissions of the subcontractor with regard to the performance or omission of any subcontractor's duties and obligations under the contract. That's the first paragraph. Those words imply that the use of the words acts or omissions imply that there has to be some culpable conduct on the part of the subcontractor. It also doesn't apply, it's express, that it has to arise out of that subcontractor's acts or omissions. And so that's the second part of our argument, that the trial court erred in not only holding Swanns responsible for the damages attributed to its own acts or omissions, and held it responsible for the other subcontractors' acts or omissions by awarding that full amount of the repair cost attributable to these defects. The second paragraph of the indemnity agreement requires indemnification and hold harmless for damages arising out of or in connection with subcontractors' work. And so that's a broader provision. So we have one that's narrow, one that's broad. They conflict with one another, and they must be construed against Amberwood, the drafter of the contract. But in any event, both of those provisions require that causation element, which was lacking from the trial court's ruling. The trial court should have, and was presented with evidence from which it could have, allocated those damages to the various subcontractors whose work contributed to the various defects. And it wasn't fair, and it wasn't in keeping with the language of the indemnity agreement to tell Swanns, we're sorry, it's a harsh result, and the trial court acknowledged that, but you go chase those other subcontractors.
If Swanns chose for a business reason to agree to that, it could, correct?
It could do what?
If Swanns chose to not explicitly have a causation requirement in the agreement for whatever business reason it had, it could do so.
Well, I suppose it could have done anything back when, it entered into the subcontract, but that was Amberwood's subcontract, and the same subcontract was presented to all the subcontractors, and they were required to sign it. So, the subcontractors...
They didn't have to enter into the agreement, did they?
They didn't have to, but if they wanted the job, they had to. So that's how it works. And, our point is that under the case law, both here in Arizona and the cases that we've cited, these provisions are construed against the drafter of the agreement. And if the drafter of the agreement wanted indemnity regardless of the negligence of the subcontractor, the courts hold that it's up to the drafter of the contractor to put that language in there. And if they don't, negligence has to be spelled out in the agreement. And, the Grubb versus Ellis case cited by the appellee holds that you don't have to use the words negligence in an indemnity agreement to require a showing of negligence. The courts look at the language and the intent of the agreement. And there's no intent in this agreement for the subcontractor to be responsible for the acts or omissions and the damages flowing from those acts or omissions of other subcontractors. And that's what happened here. If you have no further questions, I will reserve my remaining time for rebuttal. Thank you.
Thank you, counsel. Counsel?
Good morning, Your Honors. May it please the Court. My name is Jennifer Mullen, and I represent the appellees in this case, Amberwood Development, Winston Casas, LLC, and Somerset Marketing Enterprises. There are a number of issues raised in the appeal, but I think that opposing counsel as well as the Court has hit on the main issue that it is in dispute here, and that issue is the interpretation of this indemnity clause. First of all, I want to make clear to the Court that I don't believe that the indemnity clause is ambiguous. There are two separate paragraphs in the indemnity clause. The first paragraph, the paragraph that the appellant is citing, brings in the requirement that Amberwood prove negligence of the subcontractor, is not an indemnity paragraph. It doesn't have the word indemnity in it. It's only a hold harmless paragraph. It says, subcontractor agrees to and does hereby hold contractor harmless from any and all claims, etc. The word indemnity is not in there. So she not only wants you to read negligence into this paragraph when it's not there, she wants you to read indemnity into this paragraph when it's not there. The next paragraph...
Well, what is a hold harmless clause then? Isn't it an indemnity?
I believe that the hold harmless clause would apply more often during the construction, and it is saying that Swanns will not go after Amberwood related to liens and other items that come up during construction. A hold harmless can be indemnity. I do see your point, but I think in this provision it has a different meaning, because when in this indemnity clause it has a different meaning, because when you look to the second paragraph, the drafter uses not only hold harmless but also indemnity. So,
well, I guess I understand what you're saying, but I have to say that it's not clear from the first paragraph. You are saying, I think it means this. I think you should construe it this way. It doesn't say anything like that. And so it possibly could mean that, but it's your client who drafted this provision.
It is my client who drafted the provision. And they not only drafted the first paragraph, but they drafted the second paragraph. And the second paragraph does specifically talk about indemnifying and holding harmless from claims. First of all, holding harmless from claims, demands, costs, attorney's fees, etc. That is where the trial court came up with its ruling that we don't have to prove that the claims were true. Now, to be fair, I'm sure the court has read all of the pleadings and is aware, but there were two parts to this case. There was an arbitration part that actually went to judgment. So there was already liability found in the case. And the judgment was nearly everything that they had asked for. I think maybe the defendants got $100,000 off of a $2 million judgment. So it already had gone to judgment. But regardless, they needed to defend against claims without proof that the claims were true. And then the next issue that comes up, and I can tell that this is what the court is struggling with, and I know it's what Swanns struggles with, is whether or not Swanns needs to pay if they are only partially responsible for a defect. And in appellant's opening brief, they I'm sure unintentionally cut off the indemnity provision that's in the contract. But the entire indemnity provision in the contract is absolutely crystal clear that Swanns is required to pay if someone else is partially responsible. It says the defense and indemnity shall apply regardless of any active or passive negligent act or omission of the contractor, that would be Amberwood, architect, or their agents or employees. I'm fairly sure the agents or employees would include subcontractors. So the sentence is already in there.
So this provision, one could read this provision as simply transferring the burden to Swanns to prove and pursue negligence on the part of the other subs.
And that is exactly what this provision did, and that makes commercial sense. The way that these lawsuits come about and the way that construction projects are built, Amberwood didn't build anything at this project. It used subcontractors for everything. Multiple subcontractors were involved, and all of those subcontractors do something that either makes the house work or not. A number of subcontractors, their scope of work impacted soils movement issues at this house. The entire trial that we had was of connecting Swanns' work at the project to the soils allegations on a home-by-home basis from the case. That satisfies the requirements of this indemnity clause. And I don't think this is an issue of first impression before the court. Arizona courts have ruled overwhelmingly, and I believe without exception, that this type of indemnity clause is allowed if it's clear. This indemnity clause, the only thing that's the first impression is this indemnity clause finally got it right. This is what MT Builders was arguing for, but they didn't have this language. They didn't have the language that said regardless of the active or passive fault of the other subcontractors, and they didn't have separate language that again mentions negligence relating to the sole negligence or willful misconduct of the contractor. And I take exception to saying that Swanns was strictly liable. Swanns was not strictly liable here. They had a number of options that they could have used at this trial to prove that they did not owe indemnity under this clause. The number one being proving that Amberwood or its subcontractors were solely negligent for any of the defects alleged on any of the houses. They could have gone on a house-by-house basis and kicked out individual houses where it was not their responsibility, such as where a homeowner put in a pool that completely leaked and caused all the damage. They chose not to do any of that, probably because that evidence wasn't available, but regardless, they chose not to do that. They had options under this. This clause not only complies with Arizona case law, it complies with Arizona statutory law, where the legislature has looked at this issue and has made a determination that they will limit the ability for people to contract for indemnity, and they limited it so that a general contractor cannot require indemnity for his sole negligence or willful misconduct. The exact language from the statute is the exact language used in this contract. The parties intended the result that happened at this trial. The result is somewhat harsh, but the court should be aware, and the record reflected, Swanns wasn't just the guy with the rake. They weren't dinged in the case because they were standing around with a rake. Their work directly impacted the drainage at these properties, and the drainage is what caused the soils movement. That satisfies the causation, the connection of their work. It does not need to be a negligence level approximate cause. That would go with trying to recover under tort, but we're trying to recover under contract, and we set forth the causation requirement, that being that it's connected to or arising from Swanns' work.
Is there any impediment to Swanns in seeking contribution from the other subcontractors?
Well, that's an interesting question, Your Honor. The lawsuit that Swanns brought for contribution, they also brought against my client and against the homeowners. So I am uncomfortable saying this, but I am not aware of an impediment to them seeking contribution.
I guess each of the subcontractors or your client may have a particular defense to contribution, but that's for that other trial.
Well, my client's defense, and I have been dismissed from that case, although I don't believe I think the order is still being fought over. Obviously, I've got a collateral estoppel res judicata argument, and so I have been dismissed from that case. The other subcontractors are likely going to raise as a defense ARS 122504, which is the effect of a release or a covenant not to sue, which is part of UCATA. It always surprises me that I have never seen in Arizona when multiple subs settle out of a general contractor construction defect case, no one goes to the court at the time of that settlement and asks for a finding under 122504. But they don't, and they haven't. So Swanns still has the ability to argue that those settlements were not made in good faith, and that Swanns is not limited to the amount of that settlement in a contribution action, and the amount of an individual subcontractor's settlement in a contribution action. I do think they still have that ability. A little bit has been mentioned about the attorney's fees, and I'm not entirely sure that I understand what the dispute is on appeal. But I want to make sure that the court understands. There were two sets of attorney's fees. There were the attorney's fees for prosecuting the action as a prevailing party against Swanns. I don't think that's in dispute. What is in dispute is the attorney's fees under the duty to defend that was contained in the indemnity clause. The motions filed before the trial court set forth what damages were trying to be recovered. Taken out of those, or what attorney's fees were trying to be recovered, and removed from those attorney's fees were anything that didn't have to do with the defense of the case. So and I think that that's why I'm having trouble understanding what the dispute is, because I didn't get attorney's fees for anything that didn't have to do with the defense of the case. And then I just want to clarify one other thing, if I can. And I think this is a really interesting argument, and I want to make sure that it doesn't unintentionally slip by. there was an argument about whether or not Swanns was entitled to notice of the settlement. And they said that they were entitled to it because they were defending the case. First of all, they defended the case up through the judgment on the arbitration. The settlement on the litigated homes, the remaining homes, the only settlement in the case, the only part that this notice of settlement argument applies to, was 8 months later. So there was 8 months of defending a case and, quite frankly, heavy-duty trial prep, because the case was set to go to trial between Amberwood and the homeowners very shortly after that arbitration. There was 8 months that passed where the case was being defended by Amberwood alone. Swanns had answered the third-party complaint, was showing up at depositions, was clearly opposed to Amberwood at that point. But here's the interesting thing. This concept that they might have been entitled to notice, I don't see that in the case law anywhere. The case law says that they're entitled to notice of the action if there is a stipulated judgment. I can't find a case under Arizona law where it says they're entitled to notice of the settlement if there's no stipulated judgment. So I want to make sure that we don't inadvertently make new law and say that subcontractors are entitled to notice of settlement if you're going to seek indemnity from them, because I don't think that's the law in Arizona.
Could you repeat that? You're saying that there's no notice required unless there was basically a whole judgment is settling the whole case? Because the arbitration only affected certain homeowners, right?
The arbitration only affected certain homeowners. So obviously there's no notice there because that's a judgment on the merits. Right. So the notice issue only comes up on the litigated homes. It was about it ended up being a $723,000 settlement. So that notice issue only comes up there. And my point in stating that is, first of all, the trial court made a determination of fact that they were not defending, so there's no way they were entitled to notice. Second of all, that was on a motion for summary judgment brought by Swanns that was denied. If a motion for summary judgment is denied, you argue that at trial. It was not argued at trial, and in fact, my client put witnesses on that went directly and almost solely to that issue. And that witness's testimony was completely unrefuted. So, number one, I don't think that it's a good issue on appeal anyway. But number two, I want to make sure the court is at least cognizant of the fact, and I certainly could be wrong because, of course, this came to me last night as I'm trying to prep as I'm falling asleep, that I don't think there's cases out there that require a notice of settlement. If you're merely a defendant, a subcontractor defendant in a case, I don't think that you're required to notice of settlement in order to trigger indemnity. And you're certainly not to trigger contractual indemnity when your duty to defend and indemnify was already in place and you were already in violation of it. Perhaps that would give them the ability to argue that the $723,000 settlement wasn't reasonable, but that was wisely stipulated. The reasonableness was wisely stipulated to by the parties. I have about 3 minutes remaining, and I just want to briefly touch on my cross appeal. The basis of the cross appeal is that offset or recoupment is an affirmative defense. It was not pled as an affirmative defense. It was never disclosed as an affirmative defense. And I'm not suggesting that I didn't have notice that they get an offset, because certainly I obviously knew they would get some sort of offset. But I don't believe that it was my burden to prove the amount of the offset at trial. this is one of those things that is so clear that it was, in fact, difficult to find case law that stated what I believe is obvious. But the only case law I could find was Summers versus Glore, which is an Arizona Supreme Court case that states that offset is an affirmative defense.
But hadn't you stipulated that Amberwood had received a certain amount in settlement funds?
We did stipulate to that. And I'm not trying to back out of that stipulation. But the case that I put on in front of the court was Swanns is responsible for this defect relating to the movement of the homes, this defect relating to the movement of the homes. The $425,000 I got in settlement or so didn't only include that evidence that I put on in front of the court.
You're saying that although you stipulated to an amount you received in settlement funds, you then argued about Swanns' entitlement to that, or disputed Swanns' entitlement
I
to that.
did dispute Swanns' entitlement to that, but I did not put on evidence related to that because it was my belief that, truthfully, my belief was that it would be decided after the trial through motion. It's a pretty minimal amount in dispute. This was a soils case. They probably should not have gotten the credit for the roofer because I didn't claim in trial that any of the roofing damage, they didn't pay for any roofing damages in the judgment. So they probably shouldn't have gotten credit for the roofer, maybe the window guy and the painter. It's not a giant monetary dispute, but it's a giant point of contention for me because I don't like to stand up in front of the court and not be prepared to meet my burden of proof, and I certainly thought I was at the time. I am about ready to wrap up. If Your Honors have any more questions, I'm happy to answer.
No.
Thank you very much for your time. Have a great day.
Counsel. Roberto?
Yes, Your Honor. I have about 5 or 6 points I'd like to make in rebuttal. The first has to do with the indemnity agreement in the 2 paragraphs. Amberwood argues that the first paragraph doesn't reference indemnity, and I respectfully disagree. The second sentence of the first paragraph states, the indemnity extends to any claim asserted by any subsequent property owner alleging improper or defective workmanship or materials, and any work or material done or provided by subcontractor. So the first paragraph does use the words hold harmless and indemnity. I would also point out in MT Builders, the court discussed the difference between a hold harmless agreement and an indemnity agreement, and that difference has to do with whether or not the party seeking indemnity has to actually pay the judgment or the settlement. In a hold harmless situation, if it was only a hold harmless agreement, the indemnity would have to prove payment. If this was for indemnity, if it was an indemnity agreement, not a hold harmless agreement, the indemnity, with the 2 E's on the end, it doesn't require payment. So that's the difference between the 2 types of agreements, is whether the indemnity has to pay or not in order to seek indemnity from the indemnitor. The next point I wanted to make is that there's been an argument made, and it was raised for the first time today, that the second paragraph of the indemnity agreement, where it states the defense and indemnity shall apply regardless of any active and or passive negligent act or omission of the contractor, architect, or their agents or employees. That is a specific indemnity agreement. Going back to basic indemnity law, we have general indemnity and specific indemnity. The difference between the two is whether or not the general contractor can seek indemnity when it has itself been at fault in creating the damage. And so by using this specific language, Amberwood has insulated itself from a situation where it has also been negligent. It can still seek indemnity from the subcontractor. That has nothing to do with whether or not other subcontractors, whether or not Swanns has agreed to be responsible for other subcontractors.
Are subs agents?
No, they're not. And that was the point I was going to make next. Subcontractors certainly aren't employees, and they certainly aren't agents. And regretfully, it was brought up for the first time today, so I don't have case citations for you, but this may be an issue if you're considering going down this route. I would respectfully request an opportunity to brief this issue, because I feel very strongly that a subcontractor is not an agent or an employee of the general contractor. So I don't think it even applies. The next point I wanted to make is that it has to do with whether or not equitable contribution could be sought from the other subcontractors. And it's a very complicated issue, as Ms. Mullen pointed out. We have 12-2504 that may or may not come into play. And I'm not here to say that my client can't seek equitable contribution. The fact is, it is an issue that is up in the air. There is no case law on point in Arizona as to whether or not a subcontractor can seek equitable contribution from other subcontractors, particularly where releases have been given, and that's a concern. It's not a slam dunk, and that's why we're here before you today asking you to construe this indemnity agreement the way it should be construed, and only require Swanns to bear responsibility for that portion of the damages that is attributable to its work and not to other contractors' work. On the attorney's fees and notice issue, again, we have an issue raised for the first time today, and that is whether or not the case law requires notice of settlement in order to seek indemnity. We believe that the cases we cited, in particular Morris versus USAA, requires notice of settlement. It's not strictly limited to where the indemnitor is going to enter into a stipulated judgment. The cases are pretty clear that the requirement of notice is to give the indemnity an opportunity to step in and defend without a reservation of rights. And it's undisputed that Amberwood did not give notice to Swanns in this case. And as a result, Swanns received or had a judgment entered against it for about $179,000 of attorney's fees that were incurred by Amberwood with its separate counsel during a time period where where Swanns was providing a defense to Amberwood. And the record, I think, is very clear as to the fact that the attorney hired by Swanns Insurance Company, the separate attorney, continued to defend Amberwood up to and including the point where it settled with the plaintiffs. As for, it looks like I'm out of time. Just one last point. The motion for summary judgment that was referred to, the denial of the motion for summary judgment, the trial court made a specific factual finding that Swanns had repudiated its duty to defend, and that became law of the case. So that wasn't an issue Swanns could relitigate in the bench trial. Thank you very much.
We'll take this matter under advisement and we'll issue a decision in court. So thank you for your argument. We stand adjourned.